May I please, Your Lordships?
Yes.
I beg to mention item number 2, Your Lordship. On behalf of the leading counsel for the petitioner, Your Lordship, I pray this matter be listed after 2 weeks.
All right, as practical after 2 weeks.
Yes, Your Lordship.
List it after 2 weeks. Yes.
Oblige.
Lordships, I beg to mention item 29 of the hearing list.
Yes.
It's apparently this matter may come up after 2 weeks.
Same order.
I'm obliged.
May I please, the Lordship? Lordship, I beg to mention item number 6, Lordship.
Yes.
Here, the state is yet to file counter, Lordship. 2 weeks' time may be given, Lordship.
Same order.
Item number 6.
Lordship,
Yes.
I also have similar prayer for hearing item number 21 and 23, Lordship.
21 and 22.
22, Lordship.
Yes.
I pray that this matter come after 2 weeks, Lordship.
Same order. 21 and 22.
21 and 22.
Okay.
It's an analogous matter. And item number 17, Lordship.
Yes.
On behalf of Im Song, additional AG, Lordship. Lordship, I pray that this matter come after next DB, Lordship. On the next DB, Lordship. That is on 10/5/23, Lordship.
10.
Lordship.
Okay. As practical listed on 10.
Hello.
May I please, Your Lordship? Lordship, I beg to mention hearing item 18, 19, 20. There is analogous matter, Lordship.
Yes.
Lordship, here we have consensus prayer if this matter can be listed next Wednesday. Due to Lordship, here Mr. Ajo is actually out of station, Lordship.
Wednesday.
Lordship.
What is the date? As practical. Okay. Yes. Next.
Lordship, I beg to mention item number 9.
Yes.
Lordship, I pray that this matter may come after 2 weeks.
Yeah. Item 9, same order. 2
Okay,
weeks.
much obliged.
Please, Your Lordships, I beg to mention item number 25 to 28.
Yes.
Kindly list this matter after 2 weeks.
Same order.
Oblige.
May it please, Your Lordship, I beg to mention item number 23.
Yes.
I'm appearing on behalf of my senior Gauhati CGSC, representing respondent 1 and 2. With the consensus of the parties, let the matter be adjourned and listed on 10th May.
Okay. 10th May. As per. Yes.
May I please, Your Lordship, I beg to mention item 14. Lordship, here we are yet to file affidavit in reply, filed by the state respondent, Lordship.
Yes.
So if this matter can be come up after 3 weeks.
Okay. After 2 weeks. Yes, sir.
Obliged.
May I please, Your Lordship? Lordship, we have received, I beg to mention item number 13. We have received affidavit in opposition filed by the private respondent 5-74 on 27/4/23. So Lordship may kindly grant us 2 weeks time to go through their affidavit. In the meantime, if necessary, we'll file affidavit in reply.
Okay. Same order. 2 weeks. Yes.
2 weeks time.
Yes. 2 weeks.
Much obliged.
May it please, I beg to mention item number 3.
Yes.
Your Lordship, kindly allow 2 more weeks' time to file an additional affidavit.
Same order. Yes.
Yeah, please, Lordship. Lordship, I beg to mention item number 6.
Yes. 6 has already been mentioned.
Item number 4, Lordship.
Okay.
Item number 4. Lordship, I've received the affidavit filed by the respondent number 1 to 4 just this morning. So if Lordship may kindly grant me 2 weeks' time to go through the affidavit.
Same order. Yes.
Oblige,
I
Lordship.
filed it this morning, Lordship. I filed this morning. I have served the copy.
Okay. After 2 weeks.
Oblige, Lordship.
Any objection to list it after 2 weeks?
Lordship. Oblige, Lordship.
May I please, Your Lordships? Lordship, I beg to mention item number 24. Kindly we fix this matter after 2 weeks, as my senior couldn't appear today.
All right. Same order. Yes.
Much obliged.
May I please, the Lordships? Lordship, I beg to mention item number 15 on
Yes.
behalf of additional AG Im Song, Lordship.
Yes.
Lordship, I pray that this matter come after 2 weeks, Lord.
Any objection, Mr. Jami?
Lordship, on the last occasion, notice could not be completed in respect of respondent number 5, that is the CBI. I did not know whether.
CBI has filed an affidavit.
Your Lordship,
I'm mentioning on behalf of Mr. YP Gupta, learned CGC. His instructions to appear in this case, Your Worship, and he has filed one affidavit also. And he's indisposed today.
CBI?
Yes,
For
Your
the
Worship.
CBI?
Yes.
Why haven't you served a copy to the counsel for the petitioner?
I'm not aware, Your Worship.
Huh?
I'm not aware. I've just instructed.
Then they appeared. Huh?
Let the copy be served to us.
Yes.
If they have filed affidavit.
We'll serve the copy
Okay.
before the next date, Your Worship.
Not before the next date. You serve it today.
The counsel is indisposed and he's out of station, Your Worship.
You get
My
the copy of the
apologies.
counter affidavit. He has to go through it. Huh? So isn't it for
Lordship.
2 weeks? 2 weeks. Okay, same order.
Obliged, Your Worship.
For admission, item number 1.
Your Lordship, I want to make a prayer. Some new facts also arises. Kindly allow me to withdraw and with the liberty to file afresh.
2019 matter.
Yes, Your Lord.
Pleadings have been exchanged. How can we permit you that in that manner?
My Lord, this was firstly before the single bench and recast was done, but without amendment. And it has sent to division bench. So the last time, Your Lordship's law was also mentioned, the confusion. So many things change to be made. So the best thing is to withdraw and file afresh.
Just a moment. What are you challenging here? Some recruitment rule? What are you challenging here?
Your Lordship, initially, the office memorandum, but later on, the new facts arises where the Police Manual Act also come in. That is why from single bench, it has sent to division bench.
So basically, you would like to challenge the office memorandum as well as police manual.
Yes, but now it arises that I have also have to challenge the manual.
So there is no bar for challenging it. If you wish to withdraw it, you withdraw it without a leave. Leave is not necessary to challenge a statute or manual or a oil.
So my prayer is, allow me to withdraw. My prayer is, allow me to draw with the liberty to file a fresh resolution.
Mr.
K. Savi.
K.
H. Savi.
K. Savi. Learned counsel for the petitioner and Mr.
Vijimomi.
Vijimomi, learned government advocate.
Lordship.
For the respondents, Mr. So-and-so, learned counsel for the petitioner, seeks leave of this court to withdraw this writ petition with the liberty granted to the petitioner to file a press if so advised. Leave so far is granted. This writ petition is disposed of on withdrawal with the liberty granted to the petitioner to file a press if so advised. Okay.
Oblige your worship.
Item number 5.
May please. Worship, on last occasion, the government council was directed to obtain the instruction with regard to the inquiry report.
Regarding?
Regarding the indigenous inhabitant of the respondent number 5.
Please, Your Lordship.
Yes.
My Lord, by order dated 19/12/2022, State was directed to furnish the inquiry report and the action taken by the committee. So please allow me to place before Your Lordship.
What is the matter about?
Worship, the matter is, Worship, the petitioner was dismissed on the ground that since I participated in the selection process, I cannot turn around and challenge the said selection process. Worship, but as per the facts involved in the present case, that principle is not applicable. I've challenged I also appeared in the interview. The private respondent number 5, she appeared at select list number 1.
For which post? For which post?
For the post of sweeper, under the establishment of ADC Bokobutu. The establishment of ADC, Additional Deputy Commissioner Bokobutu.
Okay. Respondent number 5 was selected.
Yes, Worship. District level selection board was conducted an interview, and the private respondent number 4, she was selected at serial number 1.
Okay.
I am at serial number 2.
You are okay.
I challenge the selection of private respondent number 5 on the ground that she is not an indigenous inhabitant of Nagaland, so she cannot be appointed to the state post in violation of the memorandum state issued by the state government. Here's a memorandum issued by the state government. So the principle of, since I participate in the selection process, I cannot turn around and challenge the selection. That is not applicable. That is my case in this appeal.
So this is a reserve post for indigenous inhabitant of Nagaland.
Yes, Lordship. Yes, Lordship.
Please, Your Lordships.
Yes.
Lordships, I'm for respondent number 4, appearing on behalf of my senior Kekrimli. Since he has some personal difficulty, he's unable to appear today. And considering that I'm receiving the inquiry report only today, Lordship, I pray that some time may be given to me to go through this inquiry report, Lordship. A short date, Lordship.
Lordship, as per the inquiry report, the private respondent does not qualify to be an indigenous inhabitant of Nagaland. So the matter ends there.
And what did the learned single judge held?
Lordship, it happened like this. During the pendency of my writ petition, the state government, they have issued an order cancelling the indigenous inhabitant certificate of the private respondent number 5. So they have again filed a writ petition challenging that cancellation.
Respondent number 4.
Yes, Respondent 4. Both the writ petitions were heard together. The learned single judge has dismissed my writ petition on that opposite ground and allowed the writ petition filed by the private respondent number 4 by directing the state government to conduct an inquiry against the indigenous inhabitant of the offer. Now the inquiry is concluded. And as per this report, she does not qualify to be an indigenous inhabitant of the offer.
As per the
report.
As per the inquiry report, he
Yes,
is
Lordship.
not an indigenous.
Yes, Lordship. Lordship, we come to page number 3.
Which is the OM saying that it should be.
Lordship, in my writ petition,
is there a recruitment rule?
Lordship, it's a guideline for recruitment, Lordship. It is OM. We come to page number 44 in my writ detail, memo of detail. Page 44.
Yes.
Clause 1 and 4 is relevant. The subject is procedure for filling up of grade 3 and 4 posts in the department. Lordship, since the post in Cochin, it's with the district, so the Lordship, the clause 4 will be relevant.
Okay.
All direct recruitment vacancies in grade 4 posts in district offices of the department shall be filled up by the indigenous inhabitant of the respective district.
Respondent number 4 is not an indigenous.
She's not an indigenous inhabitant
of the district or of the state.
of the state.
Of the state.
She's an origin of Bengali. But since my learned friend is
They
asking
have
for
some, since they have
installment.
some personal difficulty.
Yes.
Some other day. When do you want?
Okay.
When do you want?
2 weeks, Lordship.
On the prayer of Mr. Sorry. This inquiry report has been submitted pursuant to which order?
Lordship, in persons to order dated 9/12/2022.
Okay, 9/12.
Lordship, the state government be directed to produce this, to bring this on record through an affidavit. The inquiry report.
This has been produced by you.
Yes, my lord.
Okay. 9/12/2022, no?
Yes, Lord.
Mr.
Lima Wapang.
Lima Wapang, Royal Constitution. Mr.
EKJ.
No, you
Itibapom.
keep on learned
For
government
the state,
advocate.
yes, my lord.
For the state and Mr.
EKJ.
Counsel for the respondent.
Number
Number 4.
Number 4.
Pursuant to order dated 9/12/2022, Mr. So-and-so and government advocate has produced, and this is what, inquiry report?
Yes. Inquiry report and the action taken by the committee, my lord. By the government, my lord.
Who had made the inquiry?
ADC.
A letter is written by subdivisional office.
Yes.
Inquiry was made by whom?
Respondent. Respondent number 3, my lord.
Who is respondent number 3?
ADC deputy, additional deputy commissioner.
ADC.
Yes.
Okay, all right. Yes. There are so many covering letters.
Yes.
Which is to be referred to?
My lord, the first one, page number 1 is a covering letter, and the second one is the decision taken by the respondent number 3. Respondent number 3, paging on letter dated page number 4.
All right.
14 November 22. Yes.
Copy of the inquiry report. Huh?
Yes, inquiry report and the decision taken.
Inquiry report. Which inquiry was conducted by?
Respondent number 3.
Deputy Commissioner Pokoputu.
Respondent number?
3.
Respondent number 3.
The additional deputy commissioner?
Yes.
Pokoputu.
Huh?
Pokoputu.
Okay, so and so. What did you say? My steno has to get the name. Oh, you go there. District, name of district? Name of the district?
District is Zeniputu. Oh, Zenhiputu.
Pugo Boto.
Yes,
under,
Pokoputu.
under the district of Zenhiputu.
This has become Juneboto.
No.
No, it is under
Pukoputu is
Zeniputu.
a subdivision under the district of Zeniputu.
So we'll say additional deputy commissioner Pugo Boto.
That
Yes.
is not the worship.
Okay, Pugo Boto. A copy of which report has also been furnished to the learned counsel for the petitioner as well as
Respondent.
as the counsel for the respondent number 4. Today, Mr. Swenson and the counsel for the respondent number 4, however, pressed for adjournment of this case by 2 weeks on the ground of some personal difficulty. In view of the above, that this as grateful listed after 2 weeks. In the meanwhile, learned government advocates file an affidavit.
Right.
No, who will file? Respondent number 3 will file.
State.
Point
By the
twenty.
state.
In the meanwhile, the state shall file an affidavit enclosing the inquiry report produced by the learned government advocate today. Please take out to me.
Much obliged.
For admission, item number 7.
May please, Lordship. Lordship, here the petitioner, he is a ward charge laborer on a fixed basis, Your Lordship, fixed pay. Then petitioner, he filed a writ petition number 347 of 2021. Nowhere in the pleadings of the petitioner did the petitioner say that he is performing similar duty as that of the regular employees, but he relied on the judgment of the Honorable Supreme Court laid down in Jagjit Singh case, as well as some judgment of this Honorable Court, where this Honorable Court has directed the state to pay minimum scale of pay. So, Your Lordship, the facts in that case are different. In one of the case, the contingent employee, he is he was appointed against a sanctioned post, Your Lordship. Whereas in the present case, nowhere he could establish that he is performing the similar duty as that of the regular employee. No pleadings was there in the writ petition. However, the learned single judge erroneously came to a conclusion that he's performing the same duty as that of the regular employee and directed the state respondent to pay the minimum scale of pay. So, Your Lordship, in a similar matter, where this court has directed the state to pay the minimum scale of pay to a contingent employees, the stake against which the state has filed an appeal, but that appeal was dismissed by this honorable court. So, Your Lordship, that case will cover the present case, Your Lordship.
Petitioner is working as?
He is a work charge labor on a fixed pay.
Work charge labor. So he has to be given a minimum scale of pay of work charge labor.
Lordship, this court has directed the state to pay the minimum scale of pay. Yes. So our contention is that since he is a work charge employee, he is not holding a sanctioned post, he cannot be given the scale of pay. This is the contention of the state. But in a similar case, this Honorable Court of Division Bench has dismissed the contention of the state.
WA 25.
Yes, in WA 25, Lordship.
So by relying on that, your submission is that this petition may be dismissed.
Yes, it will be dismissed because the division bench has dismissed the prayer.
Where is the judgment of the single judge?
Single judge, Lordship, it's at page 42.
42.
Yes. This is a common judgment, Your Lordship.
Okay. Several writ petitions.
Yes, common judgment. Then the operative part is at page 50. Yes, para 11, I've carefully gone through the case law referred by Mr. Supamwati Walin, the learned counsel for the petitioner, and I find that the ratio laid down there is strengthened his submission. In the case of Jagdick Singh, and he has quoted the judgment, relevant portion of this honorable court. Then at page 52, para 12, in view of the above factual as well as legal position, and also as agreed by the parties, this writ petition then disposed of at this admission stage itself, with a direction to the respondent authorities to take a decision upon the representation filed by the petitioners for granting minimum pay scale in the similar line with that of the petitioners of WPC such and such, and office order dated such and such, passed by the respondent number 4, that is the engineer-in-chief Nagaland Kohima. The petitioner shall obtain the certified copy of this order and place the same before the respondent number 4 within a week from today, and on receipt of the certified copy.
What is this office order?
Lordship, this is granting of scale of pay to the work charge, some of the work charge employees who approach the court. So now the contention of the stake is that since this person were erroneously granted, Your Lordship, the petitioner cannot claim the similar benefit. That is what the contention of the stake. And whereas in WPC 79 of 2018, here the petitioner in WPC 79 of 18, he is holding a sanctioned post. So Your Lordship knows that scale of pay is attached to a sanctioned post.
Which is the petitioner was appointed when?
He was appointed on 21/10/1998.
21/12/1998.
Yes.
As WC labor?
Yes,
In
work
which
charge
department?
labor. Yes.
PWD.
Yes. Lordship, his appointment is at page 28.
Okay, all right. There's no dispute on this appointment, is not it?
Lordship?
There's no dispute on this
No,
appointment?
Lordship, yes.
He was appointed on
1998, yes.
As PW at work charge level, PW, huh?
Yes, PWD, yes,
PWD.
Lordship, yes.
And which is his writ petition?
His writ petition, the Lordship, page 16.
WPC?
347 of 2021.
Okay, 347 of 21.
Yes.
His appointment order, you said?
His appointment is on 21/10/1996.
Page number?
Page 28. And the type copy is at page 40.
Type copy is at page?
40. 40.
Okay, it is legible. 21st October, no. Appointment is at page 28, you said?
Yes, 28, yes. And the type copy is at page 40. He was appointed on 21 October 1996.
Respondent herein?
Yes, Your Lordship.
Writ petitioner in WPC Q7,
347, yes.
Why did you say 2112?
2110,
Okay, 2110,
1996.
1996, not 98, isn't it? Is it page 40?
Yes.
Had Mr. Okay, no, had Miss Shukuri.
Miss Vishukri, Your Lordship.
Shukri
Yes.
learned the additional AZ.
Yes, Your Lordship.
Additional AZ for the appellant and Mr.
Subhamati Wali.
Learned counsel for the respondent, sole respondent. I think.
Yes, Your Lordship.
Respondent.
Your Lordships, I have a small submission, Your Lordship. In the earlier writ petition, Your Lordship, the earlier proceeding, the petition was disposed of only with a direction to the engineer-in-chief to consider the petitioner's representation, Your Lordship. It was not a direction for kind of scale of pay. But then, Your Lordship, the division judgment is already clear, so a specific clear direction will be given, Your Lordship.
This intra-court appeal is directed against the judgment dated 10/8/2022 passed in WPC 347/21. However, the state respondents have been directed to consider granting minimum scale of pay to the petitioner in the similar line with that of the petitioners in WPC 79K stroke 18, WPC 165K to 2018, WPC 166K 18, WPC 167K 18, WPC 168K 18, and office order dated 3/10/2018, and office order dated 23/1/2020 passed by the engineer-in-chief, Nagaland, Kohima. Full stop. The aforesaid, full stop. Such consideration was directed to be made within a period of 3 months from the date of receipt of the certificate copy of the order. The respondent herein, who was appointed as work charge labor in the department of in the office of the executive engineer PWD Kipire division by the office order dated 20 did I say work charge labor, no? Okay. By office order dated 21st October 1996, issued by the executive engineer PWD Kipire division by number KPE stroke PW stroke EST -20 at page 40 on a fixed pay of rupees 450 per month. Had filed this, had filed a writ petition being WPC 347 A of 2021 for grant of minimum scale of pay to the petitioner on the basis of Jagdish Singh was relied upon.
Yes, Your Lordship,
Okay,
yes.
on the basis of judgment rendered by the Honorable Supreme Court in State of Punjab versus Jagdish Singh, huh?
Yes, Your Lordship.
State of Punjab versus Jagdish Singh.
2017 1 SCC.
2017 on SCC.
148.
148. Full stop. Upon you had contested the case
Lordship,
in
Lordship.
the writ petition. Okay. All right. What was your contention in the writ petition?
Lordship, here the state they had not filed an affidavit.
Okay,
Yes.
they did not file affidavit.
Yes, here in
Okay,
yes in the
also.
yes.
On the contention raised by the petitioner and upon hearing the learned counsel appearing for the petitioner as well as the state respondents, the WPC 347/21 was disposed of by a judgment dated 10/8/2022. However, the state respondents were directed to consider granting minimum scale of pay to the petitioner. Post of. Though this appeal has been preferred, challenging the judgment dated 10/11/2022, passed in WPC 347/21, directing the respondent authorities to pay a minimum scale of pay to the respondent, contending that the respondent herein, who was the petitioner in WPC 347/2021, had not contended that he was discharging the similar nature of work
Yes, Lordship.
as
Entities.
work charge labor. Ms. Sukri, learned additional AZ, however, by referring to a recent judgment and order of this court dated 21/2023 in WA 25/2022 has fairly submitted that such a contention raised by the state challenge the state insofar as payment of a minimum scale of pay to the so a minimum scale of pay is concerned have been rejected in the aforesaid writ appeal, the 25/2021 post.
2022, Lordship.
Sorry, 2022.
2022, yes.
Ms. Sukri, Planet Edison AZ, therefore, submits that the present appeal may also be disposed of in the line of a judgment and order dated 21/2023, passed in WA 25/2022. Full stop. On perusal of the order dated 21/1/2023, passed in WA 25/2022, it is noticed that while the division bench of this court, while dismissing the appeal filed by the state, had directed the state authorities to grant minimum scale of pay,
Yes.
Minimum scale of pay. There also the respondent was work charge.
Here she is a contingent
Okay.
employee. Yes.
All right.
Oh,
Minimum,
yes.
minimum scale of pay on the basis of the principle of equal pay for equal work. Is not it?
Yes, Lordship.
In view of the above, this writ appeal is dismissed, being devoid of merit. In view of the above, we are of the view that the contention raised in the instant writ appeal have been dealt with by a division bench of this court in the WA 25/2022 by a decision rendered on 21/2023. Full stop. Accordingly, we find no merit in the contention raised by the state in the instant appeal, and the appeal filed by the state. Accordingly, stands dismissed. Full stop. Consequent upon dismissal of the present judiciary, we direct the respondent authorities to pay the respondent minimum scale of pay of work sales level as expeditiously as possible, and in any case not later than 3 months.
Nice.
From the date of receipt of it, copy of the certificate, copy of the certificate.
Lordship,
Copy of the-
yeah,
Yes.
I pray that a similar order may be passed in item number 8, 10, 11, and 12. Only the date of appointment will be different and the writ petition will be different.
Okay, 8,
Yeah.
8, 10, and
8, 10, 11, and 12.
11 and 12.
Yes, because this is a common judgment, Lordship.
Okay, date of appointment will be different.
And the writ petition number will be
Writ
different.
petition number will be different.
Yes.
Can you give the date of appointment of item 8?
Item number,
Note down,
item number 8, date of appointment is 7/2/1994.
Office.
Same office,
Same
Lordship.
office.
Kifiri,
All-
yes.
all
All,
people
yes,
Kifiri
Kifiri,
division.
yes, the same.
Okay,
Yes.
7 to
7/2/1994.
94. Appointment order is at page.
Page.
Your Lordship,
Page 28, and the type copy will be at page.
in the
40.
earlier
Same
command judgment, page 47, all the details have been indicated, Your Lordship.
Okay.
Page 47 of the earlier proceedings, Your Lordship, court order.
Common order.
Yes, Lordship.
Okay. All right.
Yes, page 47.
Page
yes.
47.
Yes.
All right. Secretary. Page 47. And why have you mentioned this item number 9?
Lordship, item number 9, this is not analogous.
So it
This
is
is a
different.
word charge regularization, but
Okay,
they have
all right.
put here in Lordship.
And up to 12, no? Same order.
Yes, up to 12, Lordship.
Page 47, you'll find the particulars.
Much obliged.
For orders, item number 16.
None appears. Listed after 2 weeks.
For hearing, item number 30.
Item number?
Hearing, item number 33.
Lordship, here I may be allowed to take you to page 59. Yes, 59. And the type copy will be at page 275.
275.
Yes, type copy is at page.
Why there is this, your original document at page 59 and the type copy at the
Lordship,
type copy should immediately be.
Yes, but this is the page 59. This is the writ petition. So in the writ petition, the petitioner he has not given the type copy. So the type copy came at the last, Lordship, while preparing the appeal. Lordship, here dated 16 April 1990. So this date is very important, Lordship, because here 16/4/1919, the petitioner was appointed as an assistant teacher on maths on ad hoc basis, Lordship. Then at page 71, this is dated 31/10/2002. Here,
Just a moment. What are you challenging here?
challenging is that Lordship, it's a Petitioner is a ad hoc employee, and later on he was regularized.
Ad hoc employee.
Employee, yes. And the state government, we have introduced the Assured Career Progression Scheme, SCP, in 2002. But the SCP scheme do not cover the graduate teacher because the graduate teacher are getting higher pay. That's why the SCP do not cover the graduate teacher. Only in the year 2008, graduate SCP scheme was made applicable to the graduate teacher. So accordingly, the petitioner was given the first financial upgradation in 2008. Then thereafter, in 2010, the old SCP scheme was replaced by the MSCP, new MSCP. So in the MSCP scheme, the length of service for
Just a moment.
yes.
This petitioner's ad hoc appointment was regularized when?
With effect from 14/5/2001.
14/5/2001.
Yes.
As what teacher?
As an graduate teacher, Lordship.
Graduate teacher.
Yes.
Then he had filed a writ petition,
Writ petition.
For payment of SCP.
Yes.
SCP or MSCP?
MSCP, Lordship.
MSCP.
Lordship, it's like this. In 2000, he was granted first financial upgradation in 2008.
Upgradation means?
The first scheme, that is after 12 years. Yes, in 2008. And he was erroneously granted a second upgradation in 2010 when the new SCP scheme came in.
His appointment is on and from 14/5/2000.
16/4/1990.
16/4/1990.
1990. Yes.
16/4/1990 is the ad hoc appointment.
Ad hoc appointment, yes.
So you had regularized him on
14/5/2001. Yes.
With retrospective.
No,
effect.
no. No, there is no retrospective, but the learned single judge, he counted his ad hoc service. He counted his ad hoc service and directed the state respondent to grant SCP MS second leave with effect from 2002.
Lordship, there is a misrepresentation of fact here.
No.
In
Lordship,
2000, he was appointed on a talk. 2002, interview was conducted, Your Lordship. Interview was conducted, selection board recommended him and others for regularization. What happened was, the state government regularized the local candidates, appointed them on regular basis.
But Lordship, regularization is not the issue. Regularization is not the
Yes,
issue.
Your
Only
Lordship, but the
MSCP
nature of
scheme.
appointment is
Yes.
important.
But as far as the factual part is concerned, by this time there should not be any dispute.
Yes, it is
Oh,
very
you-
clear in the judgment also, Your Lordship. It
Just
is
a
very
moment.
clear in the judgment.
You were regularized on 14/5/2001. Is that correct?
Yes, with retrospective effect.
With retrospective effect.
Yes.
From when?
From the initial appointment.
No.
Where
Page
is-
71.
Where is that?
Your Lordship.
71.
Okay. But no, Mr. Pongane.
Yes.
The regularization will take effect from 14/5/2001.
Yes.
It says.
Yes.
It will, but subsequently in the circular, if Your Lordship may go to the, if Your Lordship may go to the next page, that is, circular, which is at page 80.
80.
Yes.
Yes, with effect from 1/5/2001.
Circular, which is at page 80.
Yes, yes.
This is for pensionary benefit.
Yes.
This is for pensionary benefit.
This is also,
Yes.
this is for pensionary
Not
benefit,
for
Your Lordship, but
MSCP.
Your Lordship, initial interview was conducted. He was selected, and then when local candidates were appointed on regular basis, the petitioner was retained as ad hoc on
Just a
contract,
moment.
Your
Just a
Lordship.
moment.
Yes.
What was the writ petition about?
Writ petition was about the MACP, second lift and third lift, because ACP was granted with effect from 2002.
No.
Your Lordship will
2008.
see the order. Your Lordship, it is very clear. Your
No.
Lordship, I'm not.
He's confused.
Page,
Lordship.
page 88.
Yes.
Your Lordship will go to page
Let
88.
the
Yes,
appellate
yes.
place their case.
Yes.
Because it is not, order was issued in 2008, but 12 years, he completed 12 years in 2002. It is very clear in the order itself, Your Lordship. It's a misrepresentation of fact here, Your Lordship.
No.
The government's order itself reflects that he completed 12 years of service in 2002. Page 88. If Your Lordship may go to page 88 and page 89.
Lordship, I may be allowed to submit, Your Lordship. Yes.
Yes, let the.
Yes,
let
Your
the
Lordship,
appellant-
it is all right.
So here, Lordship, he was regularized with effect from 14/5/2001. Then at page 52, this is the SCP scheme. Page 82 is the SCP scheme. So, Lordship, it is available only to Group B and Group C on completion of 12 years and 24 years. Then at page 86,
Appellant belongs to, petitioner belongs to which group?
Your Lordship, he is getting higher pay of grade B. So the old SCP scheme do not cover the graduate teacher. And only at page 86, this is a clarification, Your Lordship. This is the scheme, page 86. This is a memorandum dated 8/4/2008. Extension of the State Assured Career Progression Scheme to graduate teachers under the School Education Department. The Assured Career Progression Scheme for state government employees was introduced by Finance Department such and such dated 28/2/2002 in order to take care of genuine hardship arising out of stagnation due to lack of adequate promotional avenues. The benefit of the SIG SCP scheme did not extend to the graduate teachers under the Department of School Education as they were provided a higher scale of pay and designated a senior graduate teacher on completion of 10 years of continuous service as per the provisions of successive ROP. On detailed examination of the prevailing exclusion of graduate teacher from the benefit of the State Assured Career Progression Scheme, it will confirm the similarly placed teachers under the central government are being covered under the respective Assured Career Progression Scheme. Therefore, after due consideration, the state government hereby extend the provision of the Assured Career Progression Scheme to graduate teachers under the Department of School Education with the following terms and conditions. Lordship, 2. The designation of junior graduate teacher shall be redesignated as graduate teacher with effect from the date of effect of this change. Page 87, Lordship, para 5.5. Those who have already completed 12 years or more of combined regular services on the date of adoption of this change shall be given the first financial upgradation on the date of effect of this change without retrospective effect. Then at point 6, Lordship, the last paragraph, the last sentence, the effective date for adoption of this change shall be the date of approval by the Governor Executive Council, that is 21/2/2008. So, Your Lordship, only on 21/2/2008, SCP was given to the graduate teacher. So, Your Lordship, at page 88, this is the order, and at page 89, at serial number 380, page 89, serial number 380, this is the petitioner's name. And the second last column, the effective date is 21/8/2008. So, Your Lordship, the SCP was given to him with effect from 21/2/2008. Then, yes, as per the office memorandum, Lordship. Then at Lordship, at page 93, this is the new SCP.
On
MSCP scheme.
21/2008.
2008.
That is after 12 years.
Yes, after 12 years.
So if you go relate back,
Yes.
then it will be his ad hoc service was included.
Lordship, that is the error that was committed by the state respondents.
Right.
Lordship, yes, he should not be given with effect from 2008.
given.
He should be given with effect from 2011 because he was regularized in 2001. Yes,
But
2001. 12, 13. Yes.
But everybody was given.
Yes, but he was given. So this is the first leave, Your Lordship. That is the mistake committed by the state government, but the state government also has not rectified. Otherwise, initially also in 2008,
Because
yes.
you see column number 1, 2, 3, 4, 5, 6, 7. Date of completion of 12 years. It is recorded as 23 for 2002.
Yes. So they have calculated.
1990 was counted.
Yes, that was the mistake committed by the department, Your Lordship. And based on this, the learned single judge has counted by taking his ad hoc service, Lordship. But Your Lordship, I'll give the clarification, the finance department clarification, Your Lordship. Because the dated effective is 21 to 2008. Because prior, if he is to be given with effect from 2002, that point of time, the SCP does not cover the graduate teacher, Lordship. Only the SCP became effective with effect from 21 to 2008.
What did you do? You withdraw the benefits from all this.
Lordship?
There are so many, page 89.
Yes.
So many names.
Yes.
You have withdrawn the benefit from all these teachers.
Lordship?
You have given the benefit,
Yes,
SCP,
we have given them the benefit.
to these assistant teachers
Yes.
whose names are here
Yes.
in the list.
Yes.
And if you see the column, that date of completion of 12 years,
Yes.
few are, say, 2005, few are 1999.
Yes.
Right?
Yes.
The benefit was first upgradation was given
Mm.
to all of them.
Yes.
Now,
yes.
did the state government withdraw the benefit from all of them?
No.
Then why he is picked up? Why this petitioner is picked up?
No. So, Lordship, I'll explain to that. Because this, we have given this 21 to 2008. So even if by mistake we have given, the old SCP scheme is not to be no more in operation and no more to be reopened. That is what the office memorandum of the finance department has stated, Lordship. So erroneously we have given to him with effect from
You have given to him and many others.
Yes, many are there, but we have not claimed anything also. Yes, Lordship. Everyone we have given, Lordship. So the old SCP scheme is superseded by the new MSCP scheme that is at page 93. This is 12 October 2010. The government of Nagaland, after careful consideration, hereby introduced the modified Assured Career Progression Scheme in replacement of the existing SCP scheme to grant 3 financial upgradation under the MSCPs at intervals of 10, 20, and 30 years of continuous regular service as indicated herein under. So, Your Lordship, under the new MSCP scheme, it is applicable to all the regular employees of Group A, B, C, and D. Then, Your Lordship, at page 94, this is very clear. Point 7, any interpretation, clarification of doubt as to the scope and meaning of the provision of the MSCP scheme shall be given by the finance department. So any interpretation or for doubt, the finance department has to give. The scheme will be operational with effect from 1/4/2010. So, Your Lordship, the finance department, they have given the clarification at page 102. Your Lordship, page 102, this is the office memorandum dated 26 August 2011. This was impugned by the respondent in the writ petition. This is dated 26 August 2011. The point raised, point number 1. It is founded in many cases the period of contract service is counted towards all service benefits like pension, leave, pay, etc., except seniority as per condition given at the time of regularization of the services. In such cases, whether such contract service should be counted as qualifying service for financial upgradation under the MSCP scheme. Then the clarification was, the MSCP scheme does not cover the employees appointed on contract at hot or overcharge basis. If any of these categories of employees are subsequently regularized and the past continuous service on contract at hot or overcharge basis are allowed to be counted for pensionary and other service benefit, Still, the seniority in service is counted from the date of regularization only. In view of this, for allowing the benefits under MSCP scheme, the qualifying length of service shall be counted with effect from the date of regularization only. The period of service rendered on ad hoc contract overcharge basis prior to regularization will not be taken into account for computation of length of service for grant of benefits under MSCP scheme. So, Your Lordship, the clarification is very clear that it will be counted from the date of regularization. Then, Your Lordship, at page 185, again, the Finance Department has given a clarification. With regard to the length of service required for availing the benefit for the second leave, yes. After receiving the first leave from the old SCP, page 185, this is the office memorandum dated 10 March 2011. Point 1. In case of incumbents who already got first financial upgradation under all SCP scheme, what will be the length of service required for giving him the second financial upgradation under the new MSCP scheme? Will it be 10 plus 10 or 12 plus 10? Then the clarification given was, since para 9 of the Finance Department notification dated 12/10/2010, introducing the MSCP scheme has stated that no past cases will be reopened. It is clarified that in case of incumbents who already got first financial upgradation under old SCP scheme, the length of service required for giving second financial upgradation under the new MSCP scheme will be 12 plus 10. That is after 10 years of service from the first financial upgradation under the old SCP scheme. It may, however, be noted that no financial upgradation under the new MSCP scheme can be granted prior to 1/4/2010. That is the date on which the scheme is made operational. So, Your Lordship, the length of service for availing the second financial upgradation will be 10 years from the first leave. Yes. So, Your Lordship, at page 100, Your Lordship. Page 100, by this order, that is order dated 24/5/2011, the petitioner was wrongly given second financial upgradation, Your Lordship. This is as per the recommendation of the screening committee of modified Assure progression scheme. The following incumbents under the
100?
Lordship.
100?
Yes, page 100, yes. Order dated 24/5/2011. Yes. By this order, the second financial upgradation was given to the petitioner. At page 101, Lordship, at serial number 496. 101, serial number 496 is the petitioner. He was given the second financial upgradation, Your Lordship, the second last column. That is with effect from 23/4/2010. The second financial lift. Because he got his first financial leave in 2008. So it should be 10 years from 2008. But the department wrongly granted him second leave in with effect from 23/4/2010. Then against which, Your Lordship, page 127. The petitioner was served a show cause notice as to why his recovery should not be made and his salary should not be fixed and recasted. Page 127. Dated 11/9/2015, show cause notice. Notwithstanding the order of the Finance Department dated such and such, the MSCP scheme screening committee had committed a bona fide error by granting the second financial leave under the MSCP scheme in the grade pay of such and such without you completing 10 years of service after the first financial upgradation as required by rules. Now, in pursuant of the judgment by the Honorable High Court via such and such, with regard to the above, you are hereby asked to justify why the department should not rectify the error committed and the excess payment not recovered from you. Your written reply should reach the undersigned within 15 days from the date of issue of this show cause notice, failing which the department will initiate the corrective measures deemed right without any further notice. So against so many show cause notice were given to those affected graduate teachers, against which those teachers they approached the High Court by filing different writ petition. Then, Your Lordship, at page 133. This is order dated 20 May 2016, page 133, order dated 20 May 2016. Impartial modification of this office order such and such, it is hereby clarified that there will be no recovery of the excess drawal of pay and allowances made owing to the run of financial upgradation under MSCP scheme to the employees in compliance to the Honorable Supreme Court judgment and order passed in such and such, and in pursuance of government notification such and such. However, the pay of those effective employees will be recasted and fixed to the lower stage of pay that he or she should have been drawn prior to the erroneous grant of financial upgradation under MSCP scheme. So, Your Lordship, against this order, the petitioner they have approached this court, that is at page 134, by filing WPC number 201 of 2016. And the learned court did not interfere into the impugned order, that is at page 135. Accordingly, the last para, page 135. Accordingly, this writ petition is disposed of without interfering with the action of the respondents with regard to recasting of the salaries of the petitioner. So, Your Lordship, the coordinate bench has not interfered into the recasting of the petitioner's salary. Whereas in the present again, the petitioner, he impugned this order recasting. So, Your Lordship, the petitioner is barred by the doctrine of res judicata, Your Lordship. Then, Lordship, Lordship may come to the prayer of the petitioner, that is at page 56. Page 56. In the premises aforesaid, it is most respectfully prayed that Your Lordship may graciously be pleased to admit this petition, call for the recourse and issue rule calling upon the respondents as to why a writ in the nature of certiorari or mandamus or any other form, question set aside the impugned portion of the office memorandum dated 26/8/2011. Your Lordship, this is the order of the Finance Department clarifying the land for the benefit of MSCP. The land should be counted with effect from the date of regularization. And the impugned orders such and such, this is 25/2016. Your Lordship, this is the recasting of his salary, Lordship, which was never interfered by the Honorable Court. Then, Lordship, page 254. Your Lordship, page 251 is the judgment passed by the learned single judge at page 195 of 2018. The date of judgment is 4/11/2020. So, Your Lordship, by this judgment, the learned single judge, he has erroneously treated his date of appointment to be his regularization date, Your Lordship. Lordship may come to page 264 of the judgment. Page 264, para 15. The 10th line, Your Lordship, 10th line from para 15. Hence, this court is of the view that 16/4/1990 will be treated as the date of regular employment for all purposes of computation of the salary and wages of the petitioner in terms of the circular dated which remains unanswered. So, Your Lordship, here the learned single judge, he has created his date of initial appointment as his date of regularization. Then, Lordship may come to page 271. I may be allowed to read. "271, Your Lordship. Second para. In such circumstances, it is always the judicial precedent that the interpretation which advances the cause of a particular at scheme or purpose is adopted. We have the notification of which is not withdrawn by the state respondents, and they in fact acted upon the same notification by granting first leave to the petitioner on 1/4/2002. Your Lordship, this is the own lordship date created by the court. He was never given the first leave on 2002. He was given the first leave on 2008 in terms of the SCP scheme. Further, what has been granted in SCP cannot be reopened. Now, by the operation of the respondent on order dated 12/10/2010, a decade has passed since the same order has took and has not been withdrawn, and thereafter with the introduction of the MSCP, the respondent cannot superimpose the application of the MSCP upon the existing right and the position of the petitioner. The position of the petitioner has already been discussed. His seniority was deprived by the state respondent. He has gone into the regularization as well as the seniority, Lordship. However, for the atonement of this missed date, it was notified that the pay and salary will be protected from the initial point of entry, which must be protected. The purpose of the scheme is to ameliorate the condition of employees who suffer from economic stagnancy in the pay structure. It will be in all fairness and appropriateness that the circular dated 28/7/2004 be read with its force for a fixation of the pay and allowances of the petitioner. The date of initial appointment, 16/4/1990, should be considered as the basis of the computation of the petitioner's years of service. That which is established has to be read in favor of the employee and not to abridge his rights and due. 21. From the above discourse, there is no doubt that the first leave under SCP granted to the petitioner was correctly given in 1/4/2002. Lordship, he was given SCP first leave in 21/2008. However, on the introduction of MSCP on 12/10/2010 by an order dated 24/5/2011, when second leave was granted with effect from 23/4/2010, there was the aberration of the OM dated 10/3/2011, which clarified that since para 9 of the Finance Department notification dated 12/10/2010, introducing the MSCP scheme, has stated that no past cases would be reopened. It clarified that in cases of the incumbent who already got first leave upgradation under old SCP scheme, the length of service required for giving second financial upgradation under the new scheme will be 12+10. That is after 10 years of service from the first financial upgradation in the old SCP scheme. Since the petitioner was granted first leave on 1/4/2002, he should be granted the second leave on 1/4/2012. This is what the learned single judge has come to the conclusion. The Lordship may come to page 273, para 25. 273, para 25. The submission of the Learned Counsel for the respondent also vividly clarifies that the employees are entitled to the third leave on completion of 30 years of service. In reply to the allegation by the petitioner that those teachers who have served only for 5 years of service in 2015-16 received third leave, it was replied that it was concerning those employees who have completed 30 years of service. By the reading of the OM data 10/3/11, column 3, and the clarification of the Learned Counsel for the state respondent, it is discernible that third leave is accorded to employees on completion of 30 years of service. The same has been adopted by the state respondent as such. Thus, from the reading of the various office memorandum by the state respondent, it can be concluded that all cases which were settled under the SCP scheme cannot be reopened as per OM dated 12/10/2010, hence granting first leave under SCP by 1/4/2002 by the strength of circular dated 27/8/74 cannot be reopened now. Number 2, by this analogy, the operation of OM dated 10/3/11, the petitioner is entitled to second leave on 1/4/2012. The grant of second leave on 23/4/2010 is therefore inappropriate as per the state respondent notification. Therefore, the emoluments drawn between 1/4/2010 and 1/4/2012 are refundable to the respondent. Number 3, the petitioner is entitled to third leave on completion of 30 years of service as per the OM dated 10/3/2011 and as per the clarification of the Learned Counsel for the state respondent. Thus, without the infringement Lordship, this is important. Thus, without the infringement of the order dated 25/2016 and OM dated 26/8/2011, the correct interpretation of the OM and circular and orders of the stake respondent, the rights of the petitioner is conceiable to the extent indicated above. It may also be added here that Sunita Chakraborty case and Nabam Protiman case are supportive of the petitioner case. So your lordship has seen that the court has not interfered into the order which the petitioner has impugned in his writ petition. The court has never interfered because without the infringement of the order dated 2/5/2016 and OM dated 26/8/2011, he has not interfered into the impugned order and he has given the direction. Then, Panitin is your lordship, 26. The respondent number 5, he is the accountant general, is directed to prepare the pay of petitioner by granting second financial upgradation with effect from 1/4/2012 and to pay the petitioner all the benefit thereafter deduction of the excess withdrawal with effect from 2/10/2012. Then, your lordship, again, this appeal is allowed, lordship. So, your lordship, though the direction was given to the accountant general for payment, it is the stake who has to pay. So, the stake has filed an appeal, the present appeal. So, your lordship, here, it's very clear that the all SCP does not cover the graduate teacher. Only in 2008, it was made extendable to the graduate teacher. And accordingly, the petitioner was granted the first leave in 2008. So after the introduction of MSCP, he will get his second leave with effect from 2018. That is 10 years from the first SCP. However, the learned single judge, erroneously, he has counted his date of appointment on ad hoc basis to be his regular service and counted his date of ad hoc service and directed the state to pay the second leave on 1/4/2012, your lordship. So there is a perverse illegality, your lordship. Lordship, I may be allowed to read some of my grounds of appeal. Lordship, at page 17. Page 17, para 3. By OM dated 10/3/2011, the Finance Department has clarified and explained para 9 of the OM dated 12/10/2010, stating in case an incumbent who already got first financial upgradation under all SCP scheme, the length of service required for giving second financial upgradation under the new MSCP scheme will be 12 plus 10. That is after 10 years of service from the first financial upgradation under the old SCP scheme. Therefore, when the writ petitioner was given first financial upgradation on 21/2/2008, his second leave will be in the year 2018. However, in spite of unambiguous clarification, the learned single judge counted the second financial upgradation of the petitioner to be on 1/4/2012. Such finding is legally untenable and totally arbitrary. Then, your lordship, lordship, at page 18, para 5. The writ petitioner was erroneously granted second financial upgradation on 23/4/2010. Therefore, by circular dated 11/3/2013, a direction was issued by the department to scrutinize all cases of MSCP second leave granted under various establishments and to recover excess pay and allowances drawn by the petitioner. Thereafter, by office order dated 25/2016, the department clarified that there will be no recovery of excess withdrawal of pay and allowances made owing to the wrong grant of financial upgradation under MSCP scheme. However, in the second paragraph of the order dated 25/2016, it is clearly stated that the pay of those affected employees will be recasted and fixed to the lower stage of pay that he or she should have drawn prior to the erroneous grant of financial upgradation under MSCP scheme. This recasting and refixing of pay was not interfered with by this honorable court in its order dated 27/6/2017, passed in WPC number such and such. The writ petitioner never challenged the order passed by this honorable court. Therefore, when the recasting and fixing of salary attains its finality, filing a fresh repetition challenging the same circular dated Lordship, it should be 25/2016, but I have made a clerical error here. Is hit by the doctrine of res judicata, and the learned single judge committed a manifest error in entertaining the writ petition. Then, Your Lordship, at page 20, para 9. Page 20, para 9. That without prejudice, the learned single judge had committed manifest error in holding that the case of Sunita Chakraborty and Naban Protima are supportive of the petitioner's case. Suniti Chakraborty judgment is against the petitioner. Firstly, at para 12 of the judgment clearly says, ad hoc or contractual appointment before regular appointment will not be counted for the benefits under the MSCP. And secondly, the judgment was passed by the Division Bench of Kolkata High Court, which is not binding on this court. Further, the judgment in Naban Protima passed by the Itanagar bench of this honorable court stands on a different footing with the present writ petitioner. The MSCP scheme under Itanagar government at para 20 of the judgment do not mention in the scheme document that the tenure of 10 years must be against regular vacancy, whereas the MSCP scheme of Nagaland government clearly stated that in order to avail the benefit of MSCP, a state government employee should be a regular government employee who has completed 10 years of continuous regular service. An ad hoc or contractual appointment before regular appointment will not be counted for the benefits under MSCP scheme. So, Your Lordship, there is illegality in the judgment passed by the learned single judge, directing the state, directing the accountant general, but it is the state who has to pay the second MSCP with effect from 1/4/2012. Your Lordship, my prayer is that such judgment cannot be sustainable in the eye of law. So I pray for question of the judgment and order, as well as the dismissal of the writ petition. That's all, Lordship.
আগৰ যিটো 2008 পৰা এফেক্টিভ হোৱা হৈছিলে ষ্টেট গভৰ্ণমেণ্টে তাৰপিছত যিসকল ৰিকভাৰী নকৰোঁ 2008 ধৰি ফাৰ্ষ্ট এপ্লিকেশ্যন তাৰপিছত ছেকেণ্ড এচিপিটো 2018 বুলি দিয়া ফাৰ্ষ্ট এপ্লিকেশ্যন 10 years so 2018 এই ৰিকাষ্টৰ অৰ্ডাৰটো চেলেঞ্জ কৰিছে
Yes, Pongen, what to do?
Yes, Your Lordship, I'll take Your Lordship to the ACB. Page 82, Your Lordship. This is the Assured Career Progression Scheme for employees of Nagaland government. As per this, on completion of 12 years, 24 years, two uplifts were to be granted.
We'll hear you some other day. But another single judge appears to have counted your service with effect from 16/4/90.
Yes.
If that goes, then the appeal would succeed.
Your Lordship?
Another single judge has counted your service from 16/4/90.
Yes, yes.
If that is found to be incorrect,
No, Your Lordship, even if that is found to be incorrect, the ACB which was granted in 2008.
Where the ACB scheme?
Lordship, the ACP is at page 82.
Page 82, Your Lordship.
ACP does not cover the graduate teacher. Does not cover the graduate teacher. Only in 2008 it covers the graduate teacher.
MSCP.
Yes,
They decided to apply the. They decided to apply the ACB to the senior graduate teachers, Your Lordship, not graduate teachers.
ACP does not
Does
apply
not
to the graduate
teacher.
It is the MSCP which applies.
No.
No, Your Lordship. It is not so.
ACP is applicable only to Group B and Group C. But since the graduate teacher they are enjoying higher scale, they do not come under these two categories. So ACP do not cover them. Only by office memorandum of 2008, the SCP scheme was made applicable, extendable to the graduate teacher. So in 2008, the petitioner was given the first MSCP scheme. So in 2008, so his second leave should be in the year 2018. That is 10 years counted from the first leave of the SCP. Whereas the learned single judge has directed us to pay SCP with effect from 2012. That will be 2 years after receiving the first leave, Lordship.
Lordship, the fact was that the petitioner was granted senior, they were designated as senior graduate teachers. Now they were being paid 35 rupees more than the junior graduate teachers at that point of time. Then what happened? When the ACB was made applicable in 2004, it was applied everywhere, only to the senior graduate teachers it was not applied. Then the government realized that this is a different, the amount which was being paid to the senior graduate teachers, the distinction of 35 rupees extra, does not justify non-application of the ACB. So they decided to apply the ACB to the senior graduate teachers also. And the distinction between graduate teachers, senior and junior was done away with. Then in 2008, first ACB was granted. Yes, but counting is to be made from the initial appointment. So obviously in 2008, when the order was passed, he had completed 12 years in 2002. It is very clear in the order itself. Yes, arrears were not paid, but as per the ACB, 12 years and 24 years of completion of service. So by 2008, when ACB was implemented, he had already completed 12 years of service in 2002. So it is clearly reflected in the order that he completed 12 years of service in 2002. So it is not the date of issuance of the order that should count, but counting should be from first 12 years, 24 years, it goes on like that.
In the SCP scheme.
Yes.
Page 82.
Yes.
It was 12 years
24
And
years.
24 is a regular service.
Yes, yes.
Now, in 86,
Yes.
it is 10 years of continuous service.
Yes.
Regular word is missing.
Regular, Lordship.
Not regular is missing.
So, Your Lordship, the clarification given by the Finance Department at page 185.
All right, we'll hear you some other day, after 2 weeks.
Otherwise, Your Lordship has heard my submission, so...
Your Lordship, the petitioner is also on the verge of retirement. Your Lordship will see that in the judgment itself, so many discriminations have been. He is from outside the state.
No, he
Your
has
Lordship.
not been discriminated. That
Others
is,
who were appointed in
beyond the scope.
1990, at the same time, whether a talk or irrespective of whether a talk or not, they have already received the third lift. Only in the case of the petitioner.
That is after completion of 30
This
years.
being-
Third leave
this
is
being-
after the completion
this
of
is being
30
done to
years.
the petitioner
Lordship.
alone.
No.
It is in the judgment itself, it is reflected. Because from the records, of this honorable court has clearly found that others who were appointed prior to 2000, at the same time as the petitioners, they have been granted the third lift of the MSCB. Normal. Only in the case of the petitioner, because he is from Bihar. Your Lordship.
Lordship, he is not challenging
this is the
those
position.
things in the writ petition. His only prayer is
It
that
is.
to quash the impugned order.
And to grant the MSCB, even
And the
without
court has
quashing also.
never quashed or interfered into the impugned order, but directed the state to pay second leave with effect from 2002. And prior, Your Lordship, in 2017, Lordship, this honorable court has not interfered into the recasting and fixing of the petitioner's salary, Your Lordship.
In the writ petition, he was not the party.
He was not a party because, Your Lordship, there are so many graduate teachers we have erroneously granted the second leave. So accordingly, we have issued show cause notice to them. So his colleague has approached this court, and the
I have
court
also-
has never interfered into that recasting of the writ petition, Your Lordship. So that it has become finality. The petitioner has never challenged that court order. So that is hit by the doctrine of res judicata. The learned single judge
Your
cannot
Lordship.
interfere. He is
When he was
precluded.
doctrine of judicata will come.
Yes.
When the same issues are
Yes.
before the court between the
Yes.
same parties.
Your Lordship,
Now,
because
if you see the definition of res judicata.
And Your Lordship, this is
Your
a matter
Lordship,
of.
a petitioner is a party.
No,
Your
no.
Lordship.
Yes, I
Please
am a
read-
party.
Please read section 11 of the CPC.
He is a party. He is a party
Yes,
in that case. He is
I
a
am
party. Yes, he
I
is a
was,
party.
I was also one of the petitioners, but the
Yes.
limited issue
Where
was,
is it? Where is it?
I
Order?
have made it in my writ petition. Also.
Where is the order?
Lordship, at page 134.
This is only with regard to, they did not challenge the,
No. Where is the single bench order?
I'll take Your Lordship.
Page 134, Your Lordship.
He was a party here.
Yes, he was a party, Your Lordship.
Huh?
He was a party. I have made specific statement in my writ petition.
Yes, in
also.
his writ petition also he has
In my
stated
writ
that he
petition
filed, Your
also,
Lordship.
But,
Where is it?
yes, Your Lordship, I'll take Your Lordship to the. Page 112, 110, Your Lordship, page 110. This was limited to the issue of, only to the issue of recovery, Your Lordship.
No.
110. It's a command
No, no,
judgment.
Lordship,
It's a
page
command
48,
judgment.
page 48.
134 order.
Page 48, Your Lordship.
133 and 134 because 133.
Yes.
Page 133.
Yes.
Yes, page 133.
Second paragraph.
Yes,
Now, 134
yes,
is one Ramakant Sharma.
yes. So, Your Lordship, here come Lordship at page 48. Page 48, the learned, the petitioner he has stated, Your Lordship, at para 20. Your Lordship say,
We are into what is this?
page 48, Lordship, paragraph 22. that his representation having not been considered, the petitioner and 4 others similarly situated teacher preferred a joint repetition before this honorable court, registered and numbered as WPC number 201K of 2016. So, Your Lordship, he is the petitioner, Your Lordship. Yes.
Whether this judgment was taken out by the learned single judge?
Lordship, nothing, Your Lordship.
Yes, yes.
So,
Yes,
no.
Which part?
No.
Reference to the WBC 201, 2019, 16.
In page 253.
Huh?
253, it is mentioned here, 253, Your Lordship.
253.
253 in the middle, which was numbered as WPC 33.
No. This one, you are a petitioner.
Yes, Your Lordship.
Page 134.
Yes.
Page 134 judgment.
Yes.
Page 134. This single judge, WBC number 201K,
Yes.
2016.
Yes.
Is it
Reflected, Your Lordship, but just only the statement at 253. Page 253. 1, 2, 3, 4, 5. The 5th line from the bottom. Page 253, the 5th line from the bottom. The representation data was filed, however, there was no response. Petitioner, along with other similarly situated person, prefer a repetition registered number WPC 201 to bring for direction to recall the arbitrary action reduction in salary to restore the salary position prior to the reduction.
The issue was very limited in that case, Your Lordship.
No, not limited.
It was.
Why not? Please see
And-
133.
Yes.
133. However, the pay of those affected employees will be recasted
Yes.
and fixed to the lower stage of pay.
Yes.
And he should have been drawn prior to erroneous grant of financial upgradation under MSCP scheme.
Yes.
That is not
Yes.
interfered with.
Yes.
Your Lordship, yes, but now the issue is the MSCB is very clear.
So did not.
So now,
Large single judge did not interfere.
Yes.
Large single
Your
judge did
Lordship,
not interfere.
in that case, yes. In that case, merit was not gone into because even the case of
No,
the
merit
petitioners
was
was.
gone, and court does not find necessity of keeping the petition between both parties.
Yes.
When no affidavit in reply has been filed by the petitioner against the affidavit in opposition
Your
filed by
Lordship.
the state respondents.
Your
So he did not
Lordship,
file
however,
reply.
yes, Your Lordship,
So
however,
matter is deemed to be admitted.
Your Lordship, but however, the MSCB and the ACB is statutory right, Your Lordship. It is a statutory right. When the time reaches, they have to, they have a right to statutory right. If the petitioners are,
Single judge has made mention of the order, but how this is dealt with, I'm not sure. 201.
because of that, Your Lordship, in this judgment, the learned single bench has said, all right, from 2012 onwards. Because what they are saying is erroneously means they were granted the first MSCB in 2010, Your Lordship. 2010. But now their stand is that they are entitled to get it only after 10 years of getting the first financial uplift. So accordingly, this honorable, the learned single bench has said that he is entitled in 2012.
I heard somebody answers it.
All right, we'll reassemble after 10 minutes. 10 minutes.
Okay, Lordship. Lordship.
Ten minutes break. Away. Pogo. And come on.
Yes, Mr. Pongeta,
Yes,
on
sure.
what ground writ petition was allowed?
Your Lordship, I'll take Your Lordship to the judgment itself, Your Lordship, because the judgment itself speaks, Your Lordship. Your Lordship, from
Where is the reasoning?
page 2.
Facts are not in dispute.
Yes,
You were appointed in 1990
yes.
as
and
an
it
ad
is-
hoc teacher.
Yes,
14/5/2001, you were
Yes.
regularized.
yes,
Then 2002 ACP scheme came into.
yes,
Teacher were not included.
yes,
2010 the scheme came where the teachers were included.
no. 2008
Eight
itself.
included.
Yes, 8 included, yes.
Teachers were included.
Yes.
Then date of effect was from 2008.
Yes,
Right?
payment was, but, yes.
Then thereafter order came
Yes.
where you were given first upgradation,
Yes.
including by counting the date of
Yes.
first upgradation from 2008
Yes,
and including a part, the entire part of your regular service plus a part of your ad hoc service. 12 years.
12 years was counted.
Where is the chart?
In
Come to the-
2012, Your Lordship.
Come to the
2002.
chart. Come to the
Yes,
chart.
come to the chart.
Let us make the point clear. Come to the chart, page 101.
Yes. No.
496.
Uh,
496.
Your Lordship, this is the 2011 one, but
Huh?
the first
Whatever.
ACB.
496. Your serial number,
Yes,
right? Now, date of effective date 1/4/2000. Sorry, 23. Why
23 for
Why
2000?
23/4?
This is the wrongly granted of second leave. This is the second leave.
Second, where is the first one?
Second leave. First one is at page 89. 89.
89.
89. Let us
Yes.
see 89.
23/4/2000.
Yes, date of completion of 12 years. Is
Come to
23
page 87.
87, yes.
Clause 6. Clause 6 is 21/2/2008, right?
Yes.
Then where is the chart? Page 89.
Yes.
Serial number
Serial number
380.
380, yes.
380. The date of effect is 21/10/2008. Right?
Yes, 2008, yes.
Uh-huh.
But date of completion of 12 years, Your Lordship. Because
and date of entry into service?
Yes.
23/4/2090.
Yeah.
It was in ad hoc.
90, yes.
It was in ad hoc.
Initial ad hoc, then subsequently it was contract.
It was in 2001 only.
Yes, Your Lordship.
So if these 12 years
Yes.
comprises of your entire regular service plus a few years of your ad hoc service. Yes or no?
But Your Lordship, what is important?
It should be yes or no.
What is important, Your Lordship? Then
We'll
yes.
come to the important part.
Yes, I admit that. 2008 is that. But date of completion of 12 years, Your Lordship. That is more important. Because 12 years is more important, Your Lordship.
Then the clarification.
Yes.
Come to page 93. MSCP.
Yes.
Page 93, MSCP. MSCP. Right?
Yes.
Now, clause 2. Clause 1. Clause 1 is MSCP at intervals of 10 years, 20 years,
Yes.
30 years
Yes.
of continuous regular service.
Yes.
Then, where is the clarification at para 9?
Page 102.
102. Your Lordship.
102.
Yes.
So this is the clarification.
The question is whether it has retrospective effect or not, Your Lordship. It cannot have retrospective effect, Your Lordship.
Why?
This is 26th August 2011. By this time, I had already been granted the first
First was
ACB
given
and the second
when?
ACB, second MACB, second lift also. This is 2011.
Where is your second MSCB order?
Second MACB is order is 2010, 2011 May. And this clarification is 26th of August 2011. Worship.
What is this judgment? Page 110.
Your Lordship, these are pertains to the group of graduate teachers who challenged the recovery of this
Yes.
excess payment on
Recovery of
wrongful
excess
granting of second leave, Lordship.
Huh? When recovery was ordered?
Recovery was ordered. We have given the show cause notice to different persons. This is page
So-
127.
Huh?
Page 127.
127.
Yes. 11 September 2015. As to why the
This was
department should not
dated
recover
11
the
yes.
excess payment.
Huh.
Yes.
11th September
One
2015.
Yes. Hang on. Recovery.
This has some role to play. This has some role to play. In respect of those teachers, so-called notices were issued in the year.
No, Lordship, it's this. We have asked them for recovery of excess payment. So the bunch of graduate teachers, they approached the court saying the show cause was not given to them. So accordingly, by this order, this court has directed the state respondent to issue show cause notice.
Where is that?
Yes, page 125.
Should be given.
Last para, 125. This court is therefore of the considered opinion that the respondent should
So
have-
recovery was not denied.
Yes.
By the court.
Yes.
But it should be preceded by so cause notice.
Yes, yes.
Right?
Yes, yes.
Yes.
So, so cause notice was accordingly issued to the petitioner.
Yes.
Show cause notice was issued the
Issued.
petitioner for recovery. Yes.
Yes.
And
recovery.
And yes, and subsequently again, when recovery was.
You replied to that.
Yes, we
Thereafter,
replied to that. Then thereafter. the
wise
judge-
sense prevailed upon the state government
Yes.
not to recover on the
Yes.
basis of
No.
the ratio laid down by Rafiq Masi. Right? So your
So in the-
excess part was not recovered on the basis
It was
of
not
this
recovered.
notification.
But whatever deductions were done already. Nothing was touched.
That is not a part of the writ petition now.
This is 110, Your Lordship. 110. This is a writ petition.
Yes. Page 20, para 25.
Yes.
125. This court is therefore of the considered opinion that the respondent should be given a show cause notice to the petitioner, thereby allowing him to represent to such show cause notice.
Yes.
Is set aside, however, state respondents are given liberty to show cause notice.
Yes.
Thereafter, take appropriate steps as per the guidelines
Yes.
contained in the office memorandum dated so-and-so of the Ministry of so-and-so.
Yes.
Permitted.
Yes.
State government was permitted.
Yes. But imperial order was set
Then
aside.
show cause notices were issued.
Yes.
Then you submitted reply.
Yes.
Then thereafter, court state government has decided by the notification at page 131.
Yes.
131, right?
Yes, these are pertains to the other group of Lordship writ petition.
Yes.
At page 133. That we will
No,
not-
in
yes.
respect of other petitioners, this order was issued.
Yes, yes,
And
okay.
similar benefit was granted to the petitioner,
Yes, yes,
right?
yes,
That is page 133.
yes,
This is common to all.
yes.
Yes.
Page 133 is common to all.
Yes.
So second paragraph. This is about recasting.
Yes,
Yes.
So recasting was also challenged.
yes.
Lordship,
Recasting was also challenged by you. Is
yes,
it not?
yes, yes, yes.
This recasting was challenged. You have mentioned, I think, somewhere paragraphs. I was taken to a paragraph. Which paragraph of the repetition?
20,
page 48.
and then
Page
48.
page 48.
Page 48. You challenged. That part was not interfered.
Yes,
So proceeded ahead.
yes.
So then you preferred the repetition.
Yes.
Yes.
Where is the prayer in the repetition?
Page 56, Your Lordship.
Direction should not be impugned portion of office memorandum. Office memorandum means
This is a finance.
2011, that
yes.
one which was for clarification, Your Lordship. The clarification that was issued.
Page 102.
Yes.
Page 102. Given by the finance department that for the benefit under MACP, it should come from the date of regularization. 102.
Yes.
and how the single judge has dealt with.
And to pay the areas with effect from now, the
Single judge has not interfered with the impugned order.
the
Lordship.
single judge has gone into only the schemes because it is a statutory right, Your Lordship.
Now come to page 164, 264.
Yeah.
Paragraph 5, 15.
264.
264. Yes.
How the last three line.
Mm.
Hence, this court is of the view that 16/4/1990 will be treated as the date of regular appointment for all purposes of computation of salary and wages of the petitioner in terms of the circular dated. What is this circular? 28/7/2004.
Your Lordship,
That was
is
after-
page 263. Page 263. The last bottom line, Your Lordship. This is a circular dated 28/4/2004. So this circular is to inform all teachers whose services have been regularized with effect from 14/5/2001 by such and such that the intervening period between the date of joining and the date of regularization will be treated as on duty for the purpose of fixation of pay and also for pensionary
Yes.
benefit. So he took
Fixation
this
of
as
pay,
a-
Your Lordship.
Yes.
And this is fixation of pay.
No, this is upgradation of financial upgradation.
Yes. It's a completely
Lordship-
different.
This is related to
Your Lordship,
financial upgradation because of the stagnancy.
Yes.
Yes.
Technician.
Your
yes.
Lordship, I'll take Your Lordship to the judgment, and then there is one Supreme Court decision which has been quoted here in the judgment
No,
itself. Your
which
Lordship.
Supreme Court decision?
Page 258. The Supreme Court has clearly held that the grant of ACP is part of the base structure.
We are not denying that.
Yes,
We are
it is
giving
part
to
of the
him.
base structure. It is
Part-
not
part of the
base structure, Your Lordship. Page 258. Page 258. This is a 258, paragraph 7, Your Lordship. With regard to the third ground, that the grant of MSCP to an employee is a part of pay construct.
Which one? Which paragraph?
Paragraph 7, page 258. the judgment. Paragraph 7. With regard, if I may read, Your Lordship.
ACP is not a statutory scheme.
Lordship, it is the Supreme Court's decision, if Your Lordship.
Where is it?
Yes.
Where Supreme Court has said the
Union of India versus Balbir Singh.
where it
Firm
is said
reported, and then
statutory scheme?
Part 10.
Where it is said?
It is a part of the pay structure. So it is.
No, where it is said?
Yes, yes.
Supreme Court.
Paragraph 10 onwards, if I may read, Your Lordship. As
where?
already held by us above. If Your Lordship may read the quotation, the paragraphs of the Supreme Court only.
Scheme has to be given a harmonized consideration to me.
Page 2 picture, last paragraph. Is already held by us. Quoting this value says, they can only dispute the ground of ACP is part of the pay structure.
Long judgment.
And your lordship, some of the decisions of this honorable court as well as some other high courts with regard to reconing of the years of
You want to rely on decisions.
if your lordship may.
Okay, then. The single judge has dealt with some issues that there was communication gap.
No,
between-
nothing, Lordship.
Yes.
Yes, nothing, Your Lordship. Your Lordship, the petitioner, he has challenges two other. One is the finance department, the other one is the recasting. So that recasting has not been interfered by the earlier judge of this court. So the single judge cannot entertain the writ petition, Your Lordship.
Oh, your lordship.
And the petitioner is never questioning that he get his first uplift in 2008. So
It's
when
a-
he get his first uplift in 2008, it should count from 2008 to 2018. From 2008, there should be 10 years in between. So he will be qualified for second leave only in 2018.
What
Yes.
are those dealt with by the learned single judge in paragraph 9, page 260 and 261?
Lordship, without prejudice to the learned single judge, he
what are
has
those?
confused himself and everything is.
What are those? I have not, we have not been taken to those.
Lordship, which page?
260 and 261.
260 and 261. 260, paragraph 9. With respect to the contention that the-
Basically, 261.
261.
Directing DDOs to scrutinize all this.
All the case, because Your Lordship, earlier in 2011, we have wrongly granted second leave, Your Lordship, to the petitioner, yes, and to the other graduate teachers. Accordingly, there was a direction to all the DDOs to scrutinize those cases, Your Lordship. So, accordingly, we have scrutinized and found that excess payment was there, so recovery should be there, against which the approach this court has directed that
Your lordship may
you should issue show cause notice.
post it to another
No,
day.
Your Lordship, everything has been heard. Even another date is given,
a-
Your Lordship. It
it's
will
an
never
issue-
improve his case. So, Your Lordship, my prayer is that
No.
it should be concluded, Your Lordship.
It's an issue of fundamental rights.
No.
When it is a part of the pay structure,
no,
my fundamental right cannot be, and there can be no waiver of fundamental rights, Your Lordship. There
No.
can be no waiver of fundamental rights.
So, whether the
I may-
petitioner is challenging, Your Lordship, in the repetition that his first SCP should be with effect from 2002. He never. So, where is the point of violation of the fundamental rights in this appellate court? He can have a avail in other appropriate forum if at all he feels so.
No.
But Your Lordship, we have extensively heard the matter. Your Lordship, I pray that no further time may be granted.
Right. 6(4)(b).
2013.
He needs to be hard in the relative condition. Any new things
Your Lordship, like I have made a submission.
apart from this? Whatever is on record.
Yes, Your Lordship.
Anything?
No, only that the with regard there is no infirmity in the decision of the learned single judge, Your Lordship. Number one, why? Because the ACB and the MACB is part of the pay structure, Your Lordship. It is a statutory right now, Your Lordship.
Subject to fulfillment of the criteria.
Yes, and then thirdly, the 2011 office memorandum saying that ad hoc services will not be
Something is
counted, cannot be
Mr.
applied retrospectively.
Convener,
Yes.
If something is erroneously given, right, at the suppose due to fault on the part of the employer, and it is realized later on, then if there is no fault on the part of the employee, then in that case, Rafiq Masih ratio in Rafiq Masih
Yes, Your
applies.
Lordship. Yes, Your
So
Lordship.
your right is limited to the extent of non-recovery of excess
That was-
payment.
Yes, Your Lordship.
But that does not mean that the employer is stopped from correcting the error.
Your Lordship, it is
Right.
admitted, but how the MACB and
Where
the-
from this one for 1990 as a regular employee has come into picture?
Your Lordship, we were appointed
You are ad hoc, it is clear.
ad hoc, yes?
14/5/2001 regularization, it is clear.
Yes, Your Lordship. We did not.
And teachers were not granted ACP. That was not challenged.
Your Lordship.
2008.
Yes.
It was
Yes.
given. You have accepted. So this is the accepted position.
Your Lordship, my humble
Okay, we'll
submission
pass
is,
the order.
Your Lordship, my humble submission is reckoning of how do they count it? The MACB, I have made, there are decisions of the
Then
learned single bench, which I have already, it is already there in the judgment also, how it is to be reckoned, Your Lordship. This is this is a welfare legislation, Your Lordship.
Welfare legislation
Yes,
does
it
not
is a
mean-
welfare legislation, and I have been discriminated from the very beginning, Your Lordship.
No, tell me.
I appeared the
Tell
exact.
me, there is any similarly situated teacher who has been granted benefit and you have been denied?
Your Lordship, I'll take Your Lordship to the judgment. In the judgment, all the details have been discussed.
No,
They are not
any
challenging
instance-
that.
Any instance? You have
Instances have been given here,
You
Your
have been
Lordship.
discriminated.
Yes.
Mr. Convener.
Instances have been given here, Your Lordship. Instances have been cited in the
Mr.
petition.
Convener.
Yes.
You want the matter to be concluded today, or you would like to
If Your Lordship may
advance some
fix it on another day, I'll do certain other researches with regard to MACB and the ACB, what the nature of the MACB and the ACB, how the dates are reckoned.
Lordship,
Because it is very clear, MACB, ACB, they are part of the base structure. It is a fundamental right. My right has been violated. Now I am on the verge of retirement, Your Lordship. The ACB is very clear, 12 to 24 years. Then it was replaced by the MACB, 10 years. Now on completion of 30 years, I am entitled to get at least, since I have been denied promotional avenues. I have been serving all these years as a graduate teacher, whereas those who were appointed at the same time, locals, who appeared at interview, who got through the interview at the same time as the petitioners. I have an
Is there
experience.
is there any promotion from post of teacher?
Yes,
What are the promotion?
assistant headmaster, and even up to the directorate level, Your Lordship.
That's why
Directorate.
in order to
Some
avoid
of
the
them
stagnation, we are given-
have now
Yes.
already reached joint directors, Your Lordship. Those who were appointed at the same time as the petitioner.
Lordship, my prayer is
Your
that
Lordship, this is the problem I have been. This is the discrimination I have been made to suffer, and there is no denying that I appeared the interview together with those who are joint directors now.
Those
I
are not
appeared the
an
interview
issue.
together. My name was recommended for regularization. I was retained as contract. These others who were selected at the same time as the petitioners in 1992, the record is very clear, Your Lordship. I have annexed the recommendations of the selection board also, Your Lordship. There is no denying the fact. They have not denied it. They are saying that yes, interview was conducted. He was
Lordship,
selected. but
MSCP is only the
he was
issue
kept
here,
under
not
contract.
the
You know, this is the-
regularization or the interview.
We'll pass orders then.
Yes.
Your Lordship may
yes,
allow,
Lordship.
allow me
No,
to
Lordship.
do some further research
No,
to
no.
satisfy this honorable court with regard to my
Yes.
to my
Lordship, my
claim.
prayer is that we have extensively heard the matter, so the interest of the stake also may be taken into consideration. And Your Lordship, even by giving the time to the petitioner, also it's not going to improve the case. So my prayer is that it should be concluded.
Yes.
We'll then pass, then we are of the view that prima facie there appears to be some merit in the case by the appellant. We in the meanwhile pass a stay order.
Your Lordship.
But the matter is at the hearing stage.
Lordship, everything has been heard. So my prayer is that the interest of the stake also may be taken into consideration.
We'll hear him next week then.
But today also we have given time. He could not establish his case, Your Lordship. So when he could not establish his case by granting further more time, he is trying to avoid this court.
No.
That is
I'm
a very
not.
sad
Next week
stage,
maybe
Your
it may
Lordship.
be posted next week.
No, Your Lordship. He's
Next
trying
week.
to avoid the court, Your
I'll-
Lordship.
I'll-
That is not in the
satisfy
interest
this
of
honorable court
justice, Your
with regard
Lordship.
to the
And again, he has filed another writ petition that is pending before, two writ petition that is pending before the single judge again. So he keeps on filing writ petition
What
after
kind of
another.
petition is pending?
Lordship,
Lordship, he has filed a writ petition wherein the third leave of MSCP has been given, taking into consideration the length of service, that is 30 years. 30 years length of service has taken into consideration that he is challenging, stating that 2012 should be the second leave of MSCP that has to be given to him, which is disputed in this writ appeal, Your Lordship.
So, Your Lordship, he has two pending writ petitions. So, what repeatedly he is filing petition after petition.
What about the second writ petition? You said two writ petitions.
Yes, one is 2018.
Yes, another one is, Your Lordship, the accountant general, as per the direction of this court, they were asked to pay. So a letter has been sent to the department because the department is compelled to send them a letter to the accountant general informing about the court order. And therefore, the accountant general has said that it is not their lookout to make the necessary payment. That is under challenge.
Your
in the
Lordship,
first
the fact is like this.
Because the
After-
order of this.
Your Lordship, in the first writ petition, Your Lordship,
We'll pass order.
Okay.
Your Lordship.
Much obliged.
We'll pass order.
Oh. Okay, we'll pass order.
Procedural, aware. Pogo. More. Court is over. Okay. Will pass order system dispose them of due. Dispose them of due without so.